single vote in the Federal Court of Appeals, which took the view that a confession's unreliability does not require that a conviction be overturned. In her dissent, Chief Judge Diane Wood called this ruling, and I quote, "a profound miscarriage of justice." It doesn't take a lawyer to see that Chief Judge Wood is right. It takes a counselor, a nurse, a mom or a dad, a teacher. It takes a person who has known someone like Brendan, someone who is all too easily coached into saying whatever he thinks his interrogators want to hear, just so he can go back to school. In his quiet, peaceful, hopeful way, Brendan has now served more than 13 years behind bars, with no chance of parole until 2048. The courts have been unable to deliver justice for him. We now ask Governor Evers to deliver that justice and bring Brendan home. We're joined today by a coalition of guests and experts, both national and local, who are here to support clemency for Brendan. You're going to hear from a number of those individuals momentarily, but I'd like to also start by acknowledging some who are here today but who won't be able to speak, including Brendan's mother, Barb, and his cousin, Carla. I'd also like to specifically acknowledge the Milwaukee Teachers Education Association, whose executive director, Ben Ward, will also not be able to speak today, but is here with us in support. And now I'd like to introduce my co-counsel and colleague, Steve Drizzen, who co-directs the Center on Wrongful Convictions at Northwestern University School of Law, where he's a nationally renowned expert on police interrogations and false confessions. Steve.
Thank you, Laura, and good morning, everybody. In October 2007, I was asked to represent Brendan Dassey on appeal. Before agreeing to take his case, I sat and I watched and listened to his interrogations. I was pretty sure what I wanted to do, but I needed a gut check. And so I gave the recordings to a student in my class, one who knew little about interrogations or confessions. That student was Laura Nyrider. And after she watched the recordings and we talked, we both knew what we had to do. We had to fight for Brendan Dassey's freedom. That fight continues today. What did we see on the confession tapes? We saw evidence of police coercion. While coercion today is more subtle than beating a suspect with a rubber hose, there wasn't anything subtle about the way the investigators broke Brendan's will. They used standard psychological tactics, tactics I've seen over and over again in 25 years of watching confession tapes, tactics which can be toxic and can produce false confessions, especially when applied to the young and vulnerable suspects like Brendan. From the first interrogation through the last, these investigators told Brendan they were not cops. They were more like father figures or friends. They threatened him by telling him that the district attorney, his office, is ready to charge you with the crime or the cover-up of that crime. They pounded him with a steady drumbeat of promises of leniency, saying he had nothing to worry about. Everything was going to be okay. It was going to be all right. They'd stand by him. They'd be in his corner. They'd go to bat for him. They weren't going to leave him high and dry. They lied over and over again about evidence, telling Brendan they already knew what happened, when in fact they didn't. And one detective kept touching him, patting his knee gently at first, and then harder as the interrogation went on. Not only did we see this coercion, but on the recordings we saw direct proof of how these tactics landed on Brendan Dassey. He actually believed that he would be set free if he just told police what they wanted to hear. Who could forget that after confessing to murder, Brendan asked, "Can I go back to school to finish a project that's due in the 6th hour?" As Laura and I dug into the record, we also came to believe that this was a false confession. Not a single piece of evidence tied Brendan to this crime. No DNA, no blood, no hair, no fingerprints. Nothing. Not in the RAV4, not in the trailer, not in the garage, not in the bird pit. Nowhere. True confessors don't need help with their narratives. The Chief Judge of the Seventh Circuit of the United States Court of Appeals described this interrogation as a ghoulish game of 20 questions in which Brendan guessed over and over again until he landed on the answer the police wanted to hear. And when he couldn't guess correctly, they led him to the answer they wanted. Who could forget how they directed him to reveal something to her head, Brendan, or who shot her in the head? This was not a contest that ended with a single knockout blow, but rather an unfair fight that led one federal judge to describe it as death by 1,000 cuts. The cuts led Brendan to confess to a crime he didn't really commit, because as he told his mother in the most simplest and basic terms, "They got to my head." We made these arguments in court, and the courts rejected them. The courts don't always get it right, and federal courts are limited in their ability to correct even obvious injustices. Where courts fail to correct injustices, or even worse, contribute to them, governors can use their clemency powers to right these wrongs. And today, we urge Governor Evers to rectify a profound miscarriage of justice and pardon or commute Brendan's sentence.
Thanks, Steve. It's now my honor to introduce Seth Waxman, former Solicitor General of the United States of America, now head of the appellate practice at WilmerHale and our co-counsel on behalf of Brendan Dassey. Over decades of experience at the state and federal level, Mr. Waxman has helped shape some of the nation's most important laws regarding juvenile sentencing, interrogation, and appellate practice. Seth.
Thank you, and good morning, everyone. It was now a few years ago that I was sitting in my office, I believe on a Sunday afternoon, getting ready for an oral argument in the Supreme Court in the coming days. And I got a telephone call from a friend of mine who was a law professor at Cornell asking whether I would have time and would be interested to assist Brendan Dassey in seeking Supreme Court review of his case. And I said, who is Brendan Dassey? And he said, "Brendan Dassey, where have you been? Brendan Dassey is the juvenile in Making a Murderer." Now, people who know me know that I have not yet quite caught up with the 1990s, much less the 2010s. And so I said, "What is Making a Murderer?" And my friend explained to me that there was a show that documented this alleged crime. And I said, "Look, just if you can shoot me relevant materials, I will take a look and let you know." And I then spent 3 hours of otherwise very precious preparation time reviewing the opinions in this case and the transcript of the so-called confession, the interrogation session, the last one that occurred in this case. And my blood ran cold. And I called up my friend and said, "I will do anything I can to help this boy." I've been a practicing lawyer since 1977. As part of my pro bono practice, in addition to representing juveniles in criminal justice proceedings, I represent death row inmates. Other than the almost 7 years that I was in the Justice Department, I've always had at least one client facing execution for a capital crime. I have never had a case that has troubled me more than this case, that has kept me awake at night, that makes me anxious and sad. And that's because I know that Brendan Dassey is innocent. And I know that no judge, not the state trial judge, not the state court of appeals judges, not the federal district judge, not any of the judges on the Seventh Circuit, including the 4 judges sitting on banc who denied his petition, and not a single justice on the Supreme Court of the United States thinks otherwise. No judge has ever written that they thought that Brendan Dassey was not innocent. That isn't the question that they presented, but it is the question that we are presenting to the governor and the board in this case. And we ask for very belated, but so desperately needed justice for this man. Thank you.
We'll now turn to Mark Osler, a former federal prosecutor and now a professor at the University of St. Thomas School of Law. Mark is a national expert on clemency and can provide some context around the clemency process both in Wisconsin and nationwide. Mark.
Thank you, Laura. I'd like to speak briefly about the nature of clemency and why this case is properly considered for clemency. Clemency is an ancient thing. It comes to us from the earliest laws, and it's necessary to balance out what Alexander Hamilton called the tendency for criminal law to become too sanguinary and cruel. And certainly we see that in this particular case. The framers recognized that no criminal case can be perfect, and very rarely are the imperfections in a criminal case as clear as they are in this one. And clemency has been historically for the unusual cases, for the ones that don't fit, for the ones that the legal system doesn't address effectively to fix. And you go all the way back to George Washington using it for the first time to pardon the leaders of the Whiskey Rebellion, Abraham Lincoln in the White House meeting with the families of people who were about to be executed for war crimes and granting clemency out of that good heart. Harry Truman granting clemency to an assassin who tried to kill him. And even closer to our own time, we see President Obama freeing over 1,700 people who were doing unfair narcotics time. And it's not a red-blue distinction either. This is a set of values that are embodied in clemency that are embraced across the political spectrum. Values of justice, mercy, and humility. And I include humility because it requires the humility to acknowledge the imperfections in our system, which are so clear in this case. Republican leaders, Haley Barbour and Mike Huckabee, when they were governors, granted many clemencies and were well known for that. Cyntoia Brown recently had her sentence commuted by the governor of Tennessee. So we don't see this as a conservative or a progressive thing. It's something that it embodies principles that go on both sides. The Pardon Advisory Board has criteria, and the governor is called upon in this case to look beyond those criteria. And in doing so, it connects to those deepest values of Americans of acknowledging imperfection, of knowing that there is a deep good in the balance that comes from not only seeking justice in the sense of punishment, but also allowing for the humility that allows mercy later in the process. Thank you.
Thank you, Mark. Now we'll turn to David Thompson, the Vice President of Operations and a certified forensic interview instructor at one of the nation's leading police interrogation training firms, Wicklander Zulawski. David and his colleagues use the videotapes of Brendan Dassey's interrogation to train police in all 50 states how not to interrogate. He's here to explain the do's and don'ts of interrogation.
Good morning. Thank you, Laura. As Laura mentioned, I represent an organization comprised of certified forensic interviewers that have the opportunity to train thousands of law enforcement investigators across the nation and across the globe on ethical, non-confrontational interview techniques. As an instructor, I'm here today to continue to create awareness and educate those that are in decision-making positions on what happened during the interrogations of Brendan Dassey. I first became aware of Brendan's case, like many people, by watching a documentary. And like most people, I was immediately frustrated and angry at the tactics used in Brendan's interrogation, and disappointed that our justice system accepted such a confession. As leaders in our industry, we discussed that if we say nothing, if we do nothing about this confession, it's just as good as accepting and condoning the techniques that are used. We realized that when you have the opportunity to make a difference, you take it, and we did. Since first becoming aware of the interrogation tapes, we've used Brendan's examples in front of thousands of investigative professionals across the globe as the prototype for how not to interrogate a vulnerable subject. Every time we show the video, I'm met with overwhelming support for Brendan and distaste for the tactics that were used by the practitioners in the room. These tactics include explicit threats of punishment, as Steve referenced earlier, promises of leniency, including statements such as, "Honesty will set you free," or "I think you're going to be okay here," removing any perception of consequences by Brendan. They also include the lack of counsel or representation for a vulnerable subject like Brendan, especially risky over the course of multiple hours of an interrogation in the interrogation room alone. Lastly, and most troubling, is the fact-feeding of information to Brendan about the details of the crime, resulting in a confused, contaminated, inaccurate confession. Nothing is more heartbreaking to me than hearing from Brendan himself immediately after the investigators leave the room, where he begins to recant his confession. And as Steve mentioned earlier, in Brendan's own words, "They got to my head." I'm here today to state that the combination of explicit promises, suggestions of leniency, the false evidence ploy, the removal of consequences, and fact-feeding a vulnerable subject like Brendan are the recipe for a false confession, and one that we should have no confidence in whatsoever. Thank you.
Next, we have Dr. Sally Miles, a Madison-based speech-language pathologist who works closely with children who, like Brendan, have speech impairments. Dr. Miles will speak to Brendan's difficulty processing and understanding spoken words and how this impairment could have led to a false confession.
Right, my profession is speech-language pathology, and that's quite a mouthful. That involves research, evaluation, and treatment of communication disorders. I've worked with children with speech and language disorders for over 30 years. I had heard of Making a Murderer, but had no intention of watching it until Professor Michelle Levine of the UW Law School asked me to watch the episode featuring Brendan Dassey's interrogation. She wanted to know what I thought of it as a speech-language pathologist. I was shocked. What I saw was a vulnerable 16-year-old high school student. He appeared to be struggling to understand the officers, and his own language expression was like that of a much younger child. Later, I found in his school records that he had been diagnosed with a severe communication disability, and yet he was alone in a room with officers, and they were barraging him with language. The episode showed an interview that broke every professional rule for interviewing a child, and especially a child like Brendan. Professor Levine and I believed that the nature and severity of Brendan's disability had been overlooked, and that a linguistic analysis of Brendan's interrogation was needed. We analyzed the interrogations as well as Brendan's educational records. Here are some of the highlights of the study. Brendan's ability to process and use spoken language was in the bottom percentile. At 16, he still struggled to comprehend spoken sentences that were only 10 to 12 words long. Over the course of 2 interviews, the officers asked Brendan more than 1,500 questions, and that is 1,500 questions. That number averaged out to 6 to 7 questions per minute for more than 3 hours. Throughout the interviews, the officers spoke in a rambling, incoherent, disorganized way that confused even our professional transcriber. She had difficulty telling where one sentence ended and another began. We concluded that Brendan would have been cognitively overwhelmed by this extraordinary amount and quality of language, and he would have said anything to bring questioning to an end. As can be seen in the videos, Brendan was extremely compliant. He acquiesced to almost everything the policeman said. The final confession was directed by the officers, their questions and their comments. It simply could not be considered to have originated with Brendan. Thank you.
Thank you so much, Dr. Miles. Now we'll turn to Jean Bishop, a nationally renowned victims' rights advocate, restorative justice expert, and defense attorney. Following the murders of Jean's sister, Nancy, along with Nancy's husband and their unborn child in 1990, Jean has become an advocate for restorative justice and victims' rights. She's here to reflect on our shared commitment to justice. Jean.
Thank you. Good morning, everyone. This case was born in tragedy, the murder of an innocent woman, Teresa Halbach, who was the exact same age as my sister Nancy when she was murdered. And so I know the pain of losing someone so dear, so young. I can't know the particular pain of the Halbach family and everyone who loved Teresa, but I do know these truths from the work I've done over the years, both as an advocate for the rights of victims in the criminal justice system and as a criminal defense lawyer. And first is that victims have no interest whatsoever in convicting an innocent person for the crime that took the life of their loved ones. That is not justice for the victim, and it creates an additional victim by convicting an innocent person for a crime that they didn't commit. The second thing is that we hope for some redemption of the tragedy, for some good to come out of the evil that had taken their lives, and for the stories of their lives not to be overshadowed by any cloud of doubt surrounding the criminal case. And the third thing that victims hope for is finality. In another high-profile case, the Boston Marathon bombing, the youngest of the 3 victims in that case was an 8-year-old boy named Martin Richards. And the government sought the death penalty in the case against Martin's killer. And the family of Martin Richards released a statement saying, we don't want the death penalty because we don't want this case to go on and to have us keep reliving the worst moment in our lives. Executive clemency provides an elegant solution to this problem. It promises both justice and finality, and I urge Governor Evers to consider it. Thank you.
Thank you, Jean. Now we'll turn to Lisa Pugh, the State Director of the ARC Wisconsin. The ARC is an organization dedicated to championing the rights of those with disabilities. Lisa has worked for many years on behalf of the disability community and has served on the President's Committee for People with Intellectual Disabilities. She'll speak to the risk of getting a false confession when interrogating someone with disabilities who hasn't been given appropriate accommodations. Lisa.
Good morning. I'm Lisa Pugh, the State Director of the ARC Wisconsin. The ARC Wisconsin advocates for and provides services to people with intellectual and developmental disabilities, or IDD, across our state. The ARC is the nation's largest civil rights organization for people with intellectual and developmental disabilities and their families. Brendan Dassey has been in prison for over a decade because of an unreliable confession that was impacted significantly by his disability. Sadly, our prisons and jails hold too many people with intellectual disabilities who are robbed of fair treatment within the justice system. Since Brendan Dassey was convicted, there has been a significant growth of knowledge and understanding of how certain individuals, including those with IDD, can be more susceptible to authority figures, coercion, and misleading tactics. Police officers, investigators, attorneys, correctional officers, and others are not adequately trained to identify people who may have intellectual and developmental disabilities or how to accommodate their needs. The lack of understanding and failure to provide accommodations all too frequently leads to tragic results. People with IDD make up 4 to 10% of the prison population, but just 1.5% of the general population. Some are incarcerated because, like Brendan Dassey, they were coerced into giving confessions, and many do not receive the accommodations to which they are entitled, putting them at greater risk. Brendan Dassey and others with disabilities have the right to justice and fair treatment in all areas of the criminal justice system and must be afforded the supports and accommodations required to make justice and fair treatment a reality. This did not happen in Brendan Dassey's case, and we call on Governor Evers to consider this when reviewing this clemency petition. Thank you.
And finally, today we've heard from legal experts, law enforcement authorities, disability advocates. We've heard a host of reasons why clemency is appropriate in this case. But I'd like to take a few moments to acknowledge that we're not here today to just talk about a legal process. This is about a person, Brendan Dassey, and his future. I'd like to introduce Kasia Madrczak. Kasia is a licensed clinical social worker who for 3 years has worked closely with Brendan. She's here to tell us about the person she's gotten to know in Brendan Dassey. Kasia.
Good morning. I'm a licensed clinical social worker who works with clients at the Center of Wrongful Convictions at Northwestern School of Law. In my professional capacity, I have been building a supportive and therapeutic relationship with Brendan by speaking to him at length at least once a week for the last 3 years. Brendan has been incarcerated since he was 16 years old. Today, he is 29 and will be turning 30 on October 19th. Let me tell you about the man that I have gotten to know. Despite all the setbacks that Brendan has endured, he has grown up into an admirable person. He has taken advantage of all the educational opportunities offered to him and earned his high school equivalency diploma. He has become a valued inmate worker with the Wisconsin Department of Corrections, where he's been a janitor, a cell cleaner, and a laundry aide. Earlier this year, Brendan even earned a transfer to a medium security facility from a maximum security prison due to his extraordinary citizenship behind bars. But even while he has grown up behind bars, Brendan still remains a simple, even childlike person. At age 29, he regularly asks me to send him pictures of angels to color. A few weeks later, Brendan sends them back, beautifully colored, and we hang them in our offices. On every phone call, we talk about his love of Pokemon and the newest characters that have come out. In fact, I'm always researching the latest Pokemon characters so I can describe them to him over the phone so he knows how to color them. And we talk about the simplest universal joys in life, such as the food he most likes to eat at the prison. Brendan is a kind and caring person. Without being asked, he regularly takes on the job of pushing the wheelchairs of geriatric inmates who need help getting around. He donates money when he can to victim awareness fundraisers that are held behind bars. He is always thinking of his family. This year for Father's Day, Brendan asked me to send him coloring pages of birds so that he could surprise his dad with them. But what's most striking to me and to our whole team is that Brendan is a deeply positive person. In 2017, when the courts denied him release, even though he had gotten so close to freedom, Brendan was the one who lifted our spirits. Even though he wasn't getting out of prison after all, Brendan tried to cheer us up by reminding us that at least he wasn't going to miss hamburger night. In honor of Brendan, we all had hamburgers that night. This gentle human being is Brendan Dassey. He does not have a violent bone in his body. As a clinical social worker, I do not have any concerns about Brendan being released into the community. I will personally guarantee that he will have the appropriate supports in place to ensure his success. I look forward to helping Governor Evers understand that now is the time to bring Brendan home.
Thank you, Kasha. Now that Kasha has reminded us all of the person who's at the center of our shared efforts today, I invite you all to get to know Brendan a little bit more. For the first time, Brendan has told his own story in his own voice, with his own words, in an interview with the podcast Wrongful Conviction with Jason Flom. We encourage everyone to visit bringbrendanhome.org, where you can listen to Brendan at age 29, reflect on his past, and talk about his hopes for the future. And then at the same website, you can make your own voice heard by signing a petition to Governor Evers, urging him to grant Brendan clemency. That's www.bringbrendanhome.org. You know, Governor Evers has said that freeing people who don't need incarceration is a moral issue. Brendan Dassey is the living embodiment of that moral issue. We look forward to working with the governor and the Pardons Advisory Board in a spirit of collaboration to support and facilitate their examination of Brendan's case. We are confident, Governor Evers, that when you look at this case, when you look at the man that Brendan Dassey has become, you will see the time is right to bring Brendan home. Thank you all for watching and listening today. We won't be taking questions from the podium, but there will be opportunities for one-on-one interviews. Thank you.